Good afternoon to all. Innovation is progress in the face of tradition. Innovation promotes culture of appreciating, supporting, and unfolding new ideas. I am Kamachi Devi from 3rd BBA to take today's webinar on IPR concept, patent drafting, and filling in India. One idea can change the world, one step to start a journey, but prayer can change all the impossible moments. Let us start with the prayer song.
Just 1 second. One second. 1 second. Actually, there's a problem in playing video. You can go ahead. You can skip and you can go ahead. Comment Devi.
Next, I would like to invite Mrs. Magalakshmi ma'am to deliver welcome address and introduce today's chief guest.
Thank you, Kamachi. Good afternoon to one and all present here. On behalf of Anai Violet Arts and Science College, it's my pleasure to welcome our dynamic secretary, sir, Mr. NRD Prem Kumar, our energetic joint secretary, sir, Dr. PER Premchand, our beloved principal, Dr. Kamala Balakrishnan, and our vibrant vice principal and IQAC coordinator, Mrs. Jafia Solomon. And our chief guest for the day is Ms. Priyadarshini Shanmugam, Director, Intellectual Property Services, Patwise Consulting Solutions. I also gladly welcome all the heads of various departments, faculty, and students to this wonderful webinar on IPR concepts, patent drafting, and filing in India, organized by our IQAC cell and innovation cell of our college. Once again, a warm welcome to you all. Now, I would like to introduce our chief guest speaker, Ms. Priyadarshini Shanmugam. Ms. Priyadarshini Shanmugam is graduated in microbiology under the University of Madras, postgraduate in biotechnology under the University of Madras, and a registered Indian patent agent. She has over 8 years of corporate and research experience in searching, drafting, filing, and protecting patents, trademarks, and copyrights. Priya has extensive experience in intellectual property over her career with leading consulting giant Accenture and specialized in IPR for pharmaceutical and biotechnology while working at Dr. Reddy's laboratory. Thank you, ma'am. Now over to our chief guest.
Thank you, Ms. Mahalakshmi, ma'am. It's a pleasure. Thank you, one and all, from the Anai Violet College for actually seeking to have a session like this on IPR. Now, I know there's going to be some bandwidth issues, so I'm going to stop my video telecast and we are going to move on to the presentation. Let me know if you need any kind of suggestions in between. So quickly, I'm going to share my screen. So what is an intellectual property rights meaning? Intellectual property rights means any rights that I get for an idea or an innovation that arises from my intellectual. So we call people intellectual once they are educated, they have creativity, they're very innovative researchers, right? So all of them create new things by virtue of their intellectual ability. They have to have certain rights over their own creations and inventions, correct? So that is what we are going to see about the intellectual property rights protection today. So there are different types of intellectual property rights based on the different means in which you use your intellectual ability. One, It can be an idea. So if you have an idea, you sit and you write a novel or you write a movie, you make a short film, a script. So all of those ideas are protected under copyright. If you have an science and technological innovation, a new mobile phone, device for capturing something. This has eventually happened is just only, intellectual credits people got instead of monetary credits. They did not get anything in terms of money or financial support. So people lose their interest in innovation. So innovators or researchers should also be financially motivated. How can they be financially motivated? If they are given a particular right to make their invention financially suitable for them. So this IPR, intellectual property rights, came into existence to give such a right to any individual inventor who wants to be financially, getting an, I would say, addendum. Addendum is something like getting a benefit out of their intellectual creation. So this gives a legal monopoly. I'll use this word monopoly throughout this particular slide. So monopoly means you are given the right, so you can stop others from using it. It's like I'm holding this home. It is my home. It is my physical property. I can stop anybody from coming inside my home, right? So a monopoly is when you stop others from using your intellectual creation. Then you create a brand value. Of course, if you start a company, it gives you a company value. So you have a share, stock value. Two other things it is you stop others from infringing, and it also gives people a sense of value. That is, you will not try and use anybody else's product without giving the due respect for them, for their intellectual creation. Of course, just like a property document, if you have an intellectual property right certificate, a granted certificate, you can use it to get a loan. So you can leverage it, you can sell it, you can keep it for licensing. It's equivalent to a property document that you hold in all its financial terms. Okay. Then goodwill and all of these are why you should protect your intellectual property. See, the reason why we are giving this, I mean, I spoke to Mahalakshmi ma'am as well. The reason why we are talking about IPR at a very student level in institutions is because when I was a student, I did not have an exposure to what IPR is. When we came out of the college and we went into real life practical scenarios, whether you work in an organization or you meet people out there, people expect you to know what IP is, what patent is, what copyright is. That tells them that, you have a sense of awareness of these important topics. And today in 2021, I'm telling you, and going forward for the next 10-15 years, these terminologies that you will probably listen to in today's webinar, it will be really applicable because you're going to read articles about patent, trademark going forward. You have to understand what it is. So I'm going to give a very in-depth as well as a very superficial, I'm going to meet at both ends so that tomorrow when you read something on a patent, you know what patent is and you know the basics of it. So you're not caught unaware of a particular topic, right? Now, intellectual property rights, if I say in India, the fire actually started. We have an Intellectual Property Act, which is the Copyright Act is way back in 1960s. The Patent Act is 1970, but it was only an act that was lying there idle. But until 1995, when we decided to do on a globalization, so India became a globalized market, and we said, okay, other companies from outside India can come inside, sell their products, and people from India, we can take our business outside, we will export, we will have companies out of India, and we will also sell it to outside the Indian consumer base. So when that kind of a trade happened, that is when 1995 onwards, this intellectual property rights became a big thing. That is, United States asked us, if two countries are getting involved in such a trade, then each other country should respect their citizens' intellectual property. So if I am a citizen of India and I have found out something new, I am going to, say, for example, Europe, and I'm starting a company there. I have a patent in India and I want a patent in Europe. I get a patent in Europe. Because I'm not a citizen of Europe, will I be treated bad? No. I will be given the same rights as I have if I hold a patent in India. I can still stop anybody in Europe also to use my product. So that kind of a mutual understanding between countries had to be there. Only then trade would be enabled. So that is when in India in 1995, a lot of talks about patent, IPR, everything started. But no, United States did not ask you to do it everything from the next day. So they gave you 10 years, right? So in 2005, we have to pass a lot of act and put all our IP acts in place. So that from 2005, 10 years later, we had to start issuing a lot of patents, even for Indian citizens, as well as from anybody outside the world. I mean, outside the country. So that's when this whole IP framework began. We started off understanding, okay, IPR is important. If I don't have an IPR act or law, then India will not be a global country. We cannot compete. So many of such agreements came into picture post 2005. And if you see whatever I've listed here in this particular slide is about the different act names. If you're interested in anything, you can go ahead, Google and read. It will be very legal. It will be like reading an act. But nevertheless, if you have the interest, you can always gain information on it. Now, there are different types of IPR. So this is like the a very eagle eye view, we say, right? From a top view, what are the different types of IPR? If I have to tell you, I'll say trademark, design, copyrights, patent, GI, and all that. So let's go to the interesting one, trademark. Trademark is something that every one of you, apart from whatever technology or your group or your study builds, you will have come across because you're all consumers. We all buy products, we all use products in the market. So we go to a supermarket, we buy stuff. Now, as a consumer, whenever I go to a shop, whenever I see two brand names selling the same product, okay, but I choose to buy one product over the other. Why would I do that? One, I would do that is because I like the taste, I like the quality of it. Fine, because, okay, say for example, I have Maggi and I have Top Ramen. I see two, both of them are instant noodles. Many prefer Maggi, few prefer Top Ramen because they know the taste. Tomorrow there's a new brand that has come. You don't know how it is. It might be better than Maggi, but it is there in the rack. You go there, you see all three brand names. You definitely don't want the Top Ramen one. But now you're confused between the Maggi one and the new one. So what will you do? Even though you don't know the taste of it or you don't know how the new brand is, you still want to stick to the brand that you're already used to. You easily buy that and come. You say, I trust it because I'm already having this particular brand for a long time, right? So that kind of a brand value that that company Nestle has created on Maggi is its revenue. Today, if you see, Maggi products are sold for X amount, right? So their product profit may be around 60%. But if Maggi sells any other product other than instant noodles, they come up with a Maggi brand of instant coffee. We may still want to try it once because we know Maggi is a brand. They are good. Their service is good. Their taste is good. So when they launch a new product, you will still associate with it. Right? So that brand name, Maggi itself contributes to around 10 to 15%. So they tomorrow they can just sell their brand name to anybody for hundreds of crores. So this is what is trademark. So any of you here tomorrow in your experience, you work with a company, then you have a brand value associated with the company. If there is any business that you will be starting tomorrow, the first thing, apart from the product or services, you have to think about a brand name for your company. And that brand name has to be very creative, very unique. And it's not that today you create a brand name and tomorrow everybody is going to recognize you. Over the years, people will start associating you with the brand name. Okay, your product with a brand name. So it's, if in case if you ask my name, people associate my name with the service that I do, patent services. And yes, Priyadarshini is a good patent agent, so I know her. So that's kind of a brand association I get. I can also have my company being associated with it or my product being associated with it. So all of these are the brand names. Now, how should a new brand name be created is, it should not be very similar. So I know Maggie is very famous. Now I want to have which is Waggy. I'm just going to invert the M into a W and make WAGGI. Don't do that. Be very unique, be very innovative. Do not cause confusion. One is you won't get a trademark for it. It's not very unique. It's not very creative of it, right? So you won't get a trademark. Plus, you will come across as a duplicate version. You won't have any authenticity, we say, right? Some uniqueness, a trust factor you will lose. So whenever you're starting something and whenever you're thinking of a brand name, do have something very unique. Do not try to imitate anybody. Do not use common words. Like if you're going to have a pickle shop, don't use pickles as your brand name. Okay. Because nobody's going to identify you with that, right? And do not, in your brand name, it's not just the name, it's also the logo, right? So do not use any images directly talking about the product. Don't put a plate with pickle for the pickle product, right? Don't use offensive trademarks. Don't use any kind of well-known trademarks also. Don't take Tata, don't take Reliance, don't take those kind of names. Be very creative. Every word that I've shown in this picture, if you see all of this, when they had started, nobody knew. It's only the quality of the product, it is only the quality of the service and the trust that the brands are still today and eventually till eternity. So a brand name is given, there is no end date for a brand name. If you get a brand name today, you can have it in perpetuity, hundreds of years, 200 years, you can have it as long as the product and service you are associating with it sticks to it. So that's how logos and brand names are done. One interesting topic about all of this is when you're creating your brand name, have a story associated with it. For example, if you see Microsoft, computer software is what they have abbreviated as Microsoft, right? And IKEA also, if you see that the name Ingvar Kamprad Limited is actually his family name. He's a Danish entrepreneur. It's family name, then followed by the name of the village, name of his house, and then his name. So it's very unique. We didn't know what IKEA is. Interestingly, Pepsi, if you see, Pepsi is a product it was initially a medical product, right? It was basically introduced to aid in digestion. It had that soda thing, it will help in digestion. So the enzyme which helps in digestion is called pepsin. So initially when they launched the product as a medical product, they used the word pepsin. Later on, when everybody started using that product and people realized from the Pepsi company realized that this is more of a consumer product than a medical product, they renamed it to be Pepsi, and now they are one of the biggest soft drinks producers across the globe. So have some kind of a story associated with your trademark. So that is the trademark. Any questions in terms of trademark, note it down. Trademark is very much applicable for the commerce and the account students. Okay, they will have a lot of clients who come and tell you that this is my trademark. How should I protect it? I want to register my company. How should I have my name of my company? So on and all of those aspects, please guide them on trademarks. And another aspect where trademark will be important for them is associating a value for a trademark. So, for example, today the Kingfisher brand, the brand name Kingfisher alone is worth at least 5,000 crores. Not their a company, not their product, just that brand name Kingfisher, right? So it's you people who will come up with a brand value based on market share, market capital, and all of that. So trademark is more applicable to you guys than for the others. Next important IPR which we will go is the designs IPR. So what is a design? Have you all seen this, the Miranda bottle that we got? So earlier, all the Coke, all the Pepsi, everything used to come in a particular template of PET bottles, right? It used to have a small cap, and then it used to be narrow along the neck, and then broaden, and then the broadest at the bottom. And suddenly, Vinanda came up with this kind of a niche packaging where they had like a bulge on the center and then it tapered in the middle, then again it bulged at the bottom. So the bottle shape itself was different. Even today in the rack, if you see all the bottles, that Miranda bottle will be slightly Miranda or Fanta, I don't know, that will be slightly different from the rest of it. So that was a bottle created to differentiate the product from the other products. So when Miranda launched, there were Coke and Pepsi. Both of them had the same dark black color, and they didn't want to be another bottle next to it. They wanted people to look at it, have a look at that, right? So they came up with this new innovative design to the product. So any design, exterior functionality to the product, and that can be protected under the designs IPR. Now you have 10 years, you can also extend to another 5 years. So basically 15 years you can have, but it should not have any functionality, right? It should only be appealing to the consumer, nothing else. So see, Bisleri, Aquafina and Kinley, all three bottles are slightly different, but they're all same purpose. They all have to do the same thing. They're all selling the same water. But why would people want you to have different shapes to their bottle? Is because so when you buy it as a consumer, you will have a trust factor towards the touch and feel of that particular product. So if I'm used to buying Aquafina, if somebody gives me Kinley, I'll be like, this is not what I used to have. Right? So you have a repulsion. So you will say, no, I want Aquafina. Similarly, if you're used to Bisleri and suddenly you see Aquafina bottle, that heavy, short bottle, it's like, no, it's not easy to carry, give me Bisleri. So what companies try and telling you is, get used to my product. I'm differentiating it and I will prevent you from using another person's product. So buy a unique design. So that is what is a design application. An interesting case on the design application I would like to tell you is women especially in the 2000s will know about using this hair removal cream that came. So we have quality products, we had Beat, we had Femme also. So the Femme, the earlier one, they had this flat spatula. So you just have to take it. It won't be like a spoon. It will be like a flat one. You apply it and then you use it to remove the cream again. So we came up with an S-shaped spatula, which you will see now. So, one end you actually take it, you apply it with the back of the S, and then you can remove and scoop it with the curved S, right? So what they did was they actually filed for a design patent. But interestingly, before we launched the product, Anne French, which is a whole brand, actually had the design for this particular S-shaped spatula. And later on, there was a case between Beat and Anne French, and Beat actually had to stop selling the product, then get a license from Anne French, and then only sell the product. So, see, for me, that S-shaped spatula is actually a very unique market. If you're a consumer and if you have observed it, you will know that people liked it because it was easy. When you're scooping something, if you have like a spoon S, it's easy to scoop things, right? So that was a big advantage for them in the market. But since they did not file a patent and Anne French already had one They actually stopped wheat from selling their products because of this. So this is one interesting case in design. Design typically for who all it is applicable, especially in medical devices, packaging. If you are into packaging, there are unique device packaging designs that come out. Medical devices also, have you heard of this insulin pen? People who have insulin, so in India many of them use the normal syringe. They take 10 ml from a bottle and then they insert, but there's called as insulin pen which has preloaded insulin to it. So you just have to set the dialer for 10 units, 20 units, and then you have to just press it and insulin is sent into your um, you can do it intramuscular also. So those kind of pens typically have in design applications, and pharma companies fight on their designs of insulin pens. So that's with respect to design application. That is also a very small niche area of production in IP, but it is picking up. There are a lot of cases that is being filed now, a lot of interesting applications that are there. Apart from this, I can tell you something interesting is the jewelry designs. So nowadays, a lot of jewelry design applications are coming. So you have this unique, they say, copyrighted. GRT says that it is our unique design, ma'am. You can never get this kind of necklace or RM anywhere else because it is our own design. They are filing for protection under design patent, and then they are saying that this is my own design. Nobody can, you cannot have or make that design elsewhere. No other competitor like your Lalita Jewelry, whoever, they can't even make the same design. So that's where designs are getting its new extensions. I found it interesting like few years back when design jewelries, unique jewelries were being protected under design application. Next we have is a copyright. What is a copyright? Copyright is very interesting because we have applications on copyright today because we all watch movies. We're all fanatics of movies. We watch short films. We like creative content, right? So copyright is directly associated with content. So any content that you create, even this presentation that I have, it is my own copyright. Nobody can take this tomorrow and say that, ma'am, we are having this slide, so it is my own slide and nobody can use it. So similarly, you create a movie, you create a video, you create anything, it is coming under literary, dramatic, and musical work. Even short term, we say sound recording, that is the jingles, even those are coming under copyrights. So what can be copyrighted is a movie, a novel, the song, script, any idea. Okay, the idea itself is not copyrighted. The expression of an idea is copyrighted. Now the term is 60 years after the death of the author. So if I have created this slide, so this slide belongs to me until 60 years after my death. So literally a person, if he creates something around his 30 years, then say 130 to 140 years, he can have copyrights to it. That's because, so today if you see Vivekananda's work was just out of copyright in 2020. Until then, all of those Vivekananda's books, whenever we buy anything which he preached, so there used to be a small amount, a copyright amount, which used to go to his family or his foundations, the Vivekananda Foundation. So that much you can actually, that person has, so it can be transferred to his legal owner and all that. So if any movie today a producer is making, then after his death, that movie rights is valid for 60 years, and if somebody is using his movie even after his death, they have to pay royalty to his kids, his children, legal heir we will say. Okay, so this is about copyright. Now, there was a controversy sometime recently with one of the music directors who was saying that if anybody is using my music composition, you have to pay copyrights. And we were like, what is this? Even he had a tiff with his own friend who was a singer. I know you all know who I'm talking about. So there was this debate in social media whether is it right is what the music director was asking. Was it right? Is he in his right frame of mind? Why is he not asking? See, I will not question anybody's intention. Whether he is doing is right or wrong, it is his own consciousness. But legally, what he said is correct. If he is the creator, we won't say author, he's a creator of his particular music composition, then anybody else who's using that music composition has to pay royalty to him. He may not be asking so much more money, but that habit of using, giving credit to the creator, that is what he's expecting should develop within the community. So it is like take it for granted and I will be using it to make my own money. No, you give credit, at least mention my name that, thanks to this creator, and then you can use it. So that we all have to have that habit of respecting someone else's creativity. Okay, most of you, some of you here who will be working on your post-graduation project works, when you see some kind of research papers online, don't just take verbatim and don't just copy it. If you're taking extra, say for example, I'm taking more than 5 lines of a particular paper, then at least in the references section, go and mention the paper, mention his name, the author's name, and say that I have taken, refer to it. Simply without giving due credit, we should not use it. So that's where copyright in your day-to-day life will come. So this is the Indian Performing Rights Society. It's a society that is created by the performing artist. So if you're going to use any of the musical compositions in any of your events, you have to write a letter to them, tell them we are going to use it. Okay, see, this is not that for your college event and all. If you're making it a commercial event, you're selling tickets and you're making money out of it, only then, okay? For individual usage and all, it's not at all a problem. When somebody is making money out of it, that's when the problem comes. So you can sit at your home, listen, you can put in your college, you can enjoy. But if I'm making an event, I'm making a ticket and I'm selling the ticket, I'm generating revenue, then I have to pay royalty to them. So this is about copyright. So far, we have seen the most interesting ones, the trademark, designs and copyrights. Any questions? Hold on. I'll come back to you after patents. I'll quickly go through patents. Patents is mostly applicable to all science and technology students. Okay. A patent is a right given to an innovation, especially in the science and technology domain. Why is it given is, like I told you in the beginning, to encourage research. So to stimulate new research. Plus when one research is done, say for example, in your college, somebody is working on plant extract of tulsi. Then in another college, 10 years down the line, they should not be working on the same plant extract, right? They should actually be working on the next innovation and technology. So this is a means where I go and tell the world that this is my innovation. I have worked on it. I have created something good. I'm, excuse me, I'm going to stop you from using it so that you work on the next technological innovation. So that's it. Excuse me, I'm just going to. Sorry. So this is about why patents is being granted. Now, for what is a patent granted? Very important. A patent is granted for any new technically advanced process or a product. Okay. I have a new telephone. I'm sorry, new mobile phone. It's a technological tool. It is a new and it is a technically advanced tool. So it has to be from the science and technology background, okay? And it has to be new. When we say new, not just in India. So I travel to Singapore, I find a new device there. I come to India and I try to make the same device in India. I tell that, nobody in India is having the device. No. It should not be available anywhere in the world. Okay, that is the most important concept. Then, if you're filing a patent for it, it has to be able to be sold in the market. See, I file a patent and I keep it locked inside my cupboard. How will it help others? I should be able to sell that product so that somebody else can pay money and use it. Only then it is good for the society. There are certain inventions which, even though it is technologically advanced, even though it is good, it cannot be patented. Very important is if it is anything related to atomic energy, nuclear energy, even if you file for a patent, you won't be granted. I mean, individuals cannot have rights on defense or all these weaponry kind of things. Okay. Then this is another important for the science students. If there is a molecule, if there is a medicine that is known, say aspirin. Common example is the aspirin, the crocin and all we have, no paracetamol. It is known, you know, it will help you in reducing your temperature. But tomorrow you find out that aspirin is helping you in reducing, say for example, asthma. Okay, then it is the same product, but you're finding a different use of it. That is not patented in India. If you're going out of India, in US and all, even that they can patent. No? But in India, because we wanted it to help people more than the innovator, we said if there is a product, we find out any new use, it's okay, but we won't give you the patent for the product. It can be used by anybody. So there are certain innovations which will not be allowed to be patented. Now, types of applications, if you see, there are two different types of application. One we call provisional application. Now there is a complete application. So for a student who is just starting his thesis work, he has an idea now, but he knows it is a very unique, he knows it is new. But by the time he finishes, it will be late. Then you file a provisional application. You are given 12 months time. You generate all the data. You work on the lab. You have all the methods and materials ready. But within 12 months, you file it with all the data. You are given that provision of 12 months timeline. Okay. Then this type of patents, different content, I will dwell on it in detail in the slide 2. Next, if you see patent process in India, so you file a patent. I'm saying not just for patent, any IPR if you see, whether it is a trademark or is a design patent, you prepare the application and you have a particular procedure in which you do it. You fill all the forms, you go, you submit it. Then the particular innovation IP is taken up by the team to examine. So if it is a trademark, they will see whether it is unique. Are they trying to copy somebody's name, all that. If it is a design, they'll see whether the design is unique. If it is a copyright, they'll see whether it is his creation or he has taken this script for somebody else. He's stealing someone's movie and all. Similarly for the patent also, the whole process called examination process. So they will examine it and they will return with a yes or a no. If it is a yes, you will be given a certificate. If it is a no, then you are given a chance to reply and see how it is different, and then you are given a yes or a no again. So there is a legal procedure in which this process happens. Quickly, interestingly, on the GI, trade secret and plant varieties, these are rarely used, okay, by individuals, but it's good to know. Geographical indication, you would have all known. You would have heard about Payani Panjamridam and then Tirupati Laddu. So any innovation, any new thing which is got its flavor because of origin in a particular area. See, if you see nowadays you're all watching a lot of YouTube videos. So all of this food review and travel videos. And people say that, this particular idli in this particular area is so nice. As a mother idli is very famous, right? And then they say that Dindakal, some meat is very famous. Why it is famous? Why do you associate the name? Because that particular rice, that particular water, that particular combination gives very inherently one unique taste to it, right? One unique flavor to it, one unique design to it. So that nobody else can claim it, and it is protected under GI. So GI is not given to any individual, it's given to an association. So Kanjivaram silk sarees. The silk sarees that are made in Kanjivaram, only people, an association in Kanjivaram can sell it as Kanjivaram saree. You cannot tomorrow in Bangalore start Kanjivaram saree and sell it as Kanjivaram saree. Only from that association it can be sold because it is GI protected. Okay. So not just Kanjivaram sarees, so many other Kashmir shawls. Okay, then you have this Madhya Pradesh Chanderi silk. Then you have Mysore Pak. There is a recent controversy whether it belongs to Karnataka or Tamil Nadu. There's a controversy that is going on. So anything, if you see, if it has an origin because of a particular place, method of preparing there, then it is protected under GI. Next interesting thing is trade secret. What is a trade secret? See, I sit in my room today and I'm thinking of something very unique. For example, I'm coming up with my grandmother's recipe to make a sambar powder. It's a very unique sambar product. My grandmother is adding three ingredients which nobody else is adding. Because of the three ingredients added in that particular way, this particular sambar powder gets an inherent unique taste. So I have, so what is the option for me? I can go and file a patent. I can go and file a copyright. Okay. But if I file it, then everybody will start using it. What is the point? So there are certain innovations, even though it is your intellectual property, you are advised not to file it. Like a KFC secret recipe, the Coca-Cola recipe. The Coca-Cola recipe, if you know, only three people in the world knows what the recipe is. It is manufactured as three different sachet packets from three different places in the world. All the three packets come to one point where they are opened and filled in the soda and becomes Coke. If you try to open the sachet, the contents vaporize. You can never identify, reverse engineer and find it out. Similarly, the Google search algorithm. You get results quickly, right? That algorithm someone has, it is a trade secret. Google never filed a patent for it. If Google had filed a patent for it, it is easy for Yahoo, it is easy for MSN, for anybody to break it. But you see, still see Google is the single most person in that particular industry who's literally working on it. Right? All this time bestseller list. Okay, interesting. New York Times every year publishes a bestseller. What is that? The novels, 10 of the bestseller novels published in that year. Nobody knows how New York Times calculates it. Only two people in New York, the New York Times newspaper, does it. They have a weighted average. So one time they'll say how many copies sold. Another time they will take it up based on content, something about the type of content. There are so many parameters which nobody knows, and so that nobody can influence and come into that list. Okay, so read these cases. It's interesting to know about it. Next you have is plant breeders, right? So if you're in the botany department, I don't know if you are there. So you guys are creating new varieties of plant, right? So for new varieties of plant, there is an IP protection given, which is depending on the type of plant. So you will have for crops 6 years, the trees and vines 9 years. Condition is that it should be expressive. It should not be just one time the crop is growing. If you take from that crop and again from the seeds, it has to be expressed. So in that case, you will get plant protection. This is very interesting, very much applicable to the botany and the agricultural students. So IPR management for colleges, I'm telling you, if you're in the colleges or anybody who's having an IP, you can do individually. If you're an holder of an IP, then you can exploit IP by selling it, assigning it, license it. I know of a student who got a patent and he got placed in a company, as one of the board directors because they said that they will take him along with his patent. So it's a startup company, but he got placed. He's working in that company. He's also in the board, and the company now has the rights to his patent. So innovation is the key to the growth. Okay. Okay, I'm not going to touch on these R&D strategies for you. It's not important. But if you're a research scholar, startup, or an organization, three things. Understanding IP is very important. So today's 1 hour is going to take is important, and I hope you guys read more about IP. Apply the principles of IP in any part of your life, whether tomorrow you're going to work somewhere, you're going to start your own business, whether you're coming up with an idea, you're a part of an R&D team, whatever it is, apply the principles. File and protect your IP if it is needed. Once you file and protect, then if you don't want, you can always give it for free. But protect it first. It should be yours so that you can give it to others. Then see if you can make money out of the IP, because that is also important, and monitor it. If you're an organization, I suggest in an institution, colleges have an innovation cell. The innovation cell should target at least filing 2 to 3 patents every year. It should encourage students in their projects to be more IP oriented so that they can file patents and they can have a set of portfolio to manage. So we help in doing it. That's what this slide talks about. We are a part of a lot of institutes who does IPR, innovation management. So any of your students, if they are having some products, some innovations, research thesis, and if they feel it is good and it has to be patented, do reach us. We'll help you in all of that. This is about my company, not needed for you. You can always Google it. Now, if you have any questions for this session, you can ask me right away for the next 5 minutes.